Okay, so hi to all the people at home. This is the week 8 tutorial for contracts in T3 of 2022. Nice to meet you all. If I didn't catch you at the first tutorial, I'm AJ. If you're thinking, where's Peter? He has stepped back for the next 3 weeks. And I'll be stepping in for weeks 8, 9, and 10. So in those weeks, we discuss the vitiating factors, and they're a very meaty little section of the unit. And so we expand the tutorial time frame to allow for ample discussion. Now, if we can get away in less than 2 hours and you're all happy chappies and, you know, rocking and rolling with the concepts involved, then that's fine. But if not, that's also fine, and we will stay here for the 2 hours. Normally, the way it will work is that I run things a little bit differently to Peter. So what I like to do is a bit of revision for the week's content, just so that everyone's kind of on the same level playing field for when we actually go and have a little look at the problem. And then we'll watch the video together and try and pull it apart and do a bit of an IRAC together. So that's the way that I normally run things. Yeah, if you have any questions or queries about any of that, please do let me know. I am a frequent flyer on the team's websites. So if you have any problems or queries over these next 3 weeks, please do pop a post up on Teams. As I said, I'm always on there, and I'm more than happy to answer any curly questions that you might have. I will alert you to the fact that typically, I mean, I won't be drafting the end of term paper this term, obviously, because Peter's running the unit this term. But typically for the end of term paper, these vitiating factors tend to make an appearance somewhere. So it's a great idea to kind of get all of the curly questions ironed out as we go along, rather than leaving, you know, leaving things to the very end and then finding that this stuff's on the take-home paper. Okay, so before we actually kick it off proper, I just would like to do a welcome to country and acknowledge the traditional owners of the land on which we work and play in our various places that we're meeting tonight, and the leaders past and present and emerging. Okay, so let me share my screen. Okay, and I will get up the. So we'll do illegality first. And just, oh, is this the, yes, this is the form. Good, good, good. So what I want to do first is just a little bit of kind of definitional work, because now we're getting to the pointy end of the term. You have to be absolutely crystal clear on the very important terminology that we use to describe the various problems that you can have with a contract that arise from the intervention of one or more of these vitiating factors. So first, can somebody tell me what a void contract is? A void contract. Just open mic it. Oh, I haven't got me. Sorry if you've just typed it into the chat box. I've got my chat box open. Oh, no one's typed it into the chat anyway. That's lucky that time. Okay, so a void contract. What is the characteristic or characteristics of a void contract? What does it mean? You can open mic.
So it would have no basis to even really form a contract. Like it wouldn't have any factors to make it.
It has no basis. Yes. So normally when you say a contract is void, it means it's void ab initio. It means it never even got off the ground. Yes. So that means in terms of passing property in title to an item, what's happened? Is it effective enough to pass title? So if I sold you my car and there was an intervening vitiating factor and that contract was held to be void, can it have passed title to you?
No, it can't.
Ooh, hooray! There's life out there. I can't see any of you folks because the screens are all black, so it looks like it's kind of Dion and me at the moment. Oh, there's my alarm to say don't forget the contract tutorials on. That's right. You can't pass title via a void contract because you never had a contract in to start with because it's void ab initio. Yes? Lovely. Okay, so in between void contracts and voidable contracts, there is another little beastie called unenforceable contracts. Unenforceable contracts. So what is an unenforceable contract?
Is that a contract that the court will not enforce?
Absolutely. Absolutely. Now, has that contract ever existed? Does it exist? What is the story? Is it some kind of ghost that just kind of floats around in the background? What is the nature of an unenforceable contract? Can it pass title? That's your litmus test.
I think an unenforceable contract can potentially pass title.
Do you want to explain that a little bit more? No. Jay, don't ask follow-up questions. It is there, it exists, and if the parties are happy enough to play with each other and perform their parts of the contract, then everyone walks away happy. The only problem with an unenforceable contract is if one of the parties spits the dummy, does the wrong thing, and the other party wants to run off to court. Okay. Now, in that circumstance, you're absolutely right. The court will not enforce that contract. Okay. So it's valid enough to, it's valid enough to pass title, but courts won't enforce it if you get into trouble. Now, can anybody give me an example of a statute that will make, or an example of an unenforceable contract? Classic example. No? These kinds of contracts often arise where the contract has been concluded. For example, I agree to sell you my house and land. The only problem is that the Property Law Act requires all contracts for the sale or disposal of real property to be in writing. So we call that a formalities requirement. And where your contract doesn't comply with that kind of thing, it'll be unenforceable. Okay. All right. And then at the other end of the I was going to say pendulum, but you can't have an end of a pendulum. Well, I suppose you can. Voidable contracts. Voidable. So they're not void, They're not unenforceable, they are voidable. What's the deal with these little beasties? Is the contract on foot? Is it sufficient to pass title? Is there a problem with it?
So avoidable one would be if one of the parties has a right to repudiate or like withdraw from the contract. That would make it voidable.
Yes. If a contract is voidable, one of the parties who's the innocent party has the right to avoid the contract that is repudiated. Exactly. Now, up until that time, what is the status of that contract? Is it valid to pass title?
Yes.
That was like, yes, ... question mark. Yes, you're right. It's valid enough to pass title, and it will go on pretty much like an unenforceable contract until there's a problem and one of the parties realize that there's been the intervention of one of these vitiating factors. They put their hand up and they say, I want to rescind. I want to rescind is the technical term for it. Repudiation is actually something slightly different, but I got what you mean. One of the parties will say, I want to rescind. And then the other party will probably say, oh, no, you can't. And then they'll say, oh, yes, I can. And no, you can't. Yes, I can. No, you can't. Yes, I can. And they'll run off to court. And then the court makes a decision about whether that person repudiated successfully or not. Okay. So that's the nature of a voidable contract. Now, the only problem with a voidable contract, apart from its vulnerability, is that the vulnerability itself, so the right to rescind itself, is subject to a number of rules, and you can't rescind in circumstances where equity wouldn't feel right about it. And this is where we really start to see equity cutting across the issues that we discuss here in contract law. Okay, so if equity says, yes, you've got the right to rescind, but it doesn't smell right in the circumstances, then you're not going to be able to rescind. So what are those circumstances that might make it not smell right? Those circumstances are things like the intervention of an innocent third party purchaser, right? So if you've got a voidable contract, like I said, valid enough to pass title, might even pass title to a rogue who then sells to an innocent third party at the end of the day. All of a sudden, you've got this innocent third party in the mix. The first person that's been dudded by selling to the rogue sues the rogue to try and rescind the contract, but we have this intervention of a bona fide third party. Okay, and in those circumstances, equity says, no, sorry, can't rescind. There's a stack of those bars to rescission, and I'll expect you to know all about those for next week's tutorial. Okay, so that is a voidable contract. Now, what about illegal contracts? What is the bottom line with illegal contracts? The bottom line consequence of illegal contracts.
That it may never have been a contract to start with.
Yes.
What are you thinking?
Yes. So, and how is it different to a void contract? Anyone can jump in. What's the
Prohibited under statute.
That's one example. That's one example, and we'll certainly get to that in a second. But I'm looking for the consequence at the bottom of the line. If we have this illegal contract, it might be illegal under statute, it might be illegal via common law. But if we have one of those beasties, what is the extreme result? It's not just void. There's something more. There's a consequence, and it's a Latin phrase. I feel like I'm in charades. 3 words. First word.
I don't remember the Latin phrase, but I know that the parties may not be able to, well, they can't seek a remedy.
You're getting in the right direction there. What's the Latin phrase, though? We've got to be up to date with our legal technical terms. Ex turpi.
Is it causa non orator actio?
That's the full, yes. Most lawyers just call it ex turpi causa or ex turpi. Okay. Ex turpi is the, sorry, that's my dog. His name is Ollie. Ex turpi causa. Now, if your contract's void, there are still some slim lines of pursuit that you can follow in order to try and get some remedies, okay? But with a contract that has been declared illegal and has the consequence of ex turpi causa, have a look at all of the consequences here. No damages, no recovery of amounts due. You can't terminate for breach, no rescission, no specific performance, no injunctions, and no other equitable remedies like rectification. Okay, so it's extreme. It's just nada. nada. Okay, so that's why it's super duper important to be able to identify an illegal contract. And that's why so many people try, when they really want to get out of a contract, will try to argue illegality. But let me tell you, it's not that easy to successfully argue illegality, as we'll find out with the tutorial problem. Okay, so now let's get on to the content proper. And before we do that, can I just have a little indication? And this is not a waggling finger moment. This is just me knowing where to pitch the tutorial. Can I have a 1 in the chat box if you managed to get across the materials for this week, or a 2 in the chat box if you haven't, or a 2.5 or 1.5 if you you had a little bit of a look and, you know, but you're feeling a little bit wobbly. Okay, I understand. I get that, Dion. I get that totally. Okay, so some people have responded. All right, so it looks like most of you folks haven't had a chance to get across the readings. Okay, that will make our interaction a little bit difficult in terms of trying to work out an IRAC solution to the tutorial problem. So what can I ask you, did anyone manage to look at the mistake materials for this week? So 1 if yes, 2 if no, 1.5 if, you know, you just kind of had a cursory glance. So 2s, all right, 2, okay. Well, we may be getting out of here a little earlier than we first thought. What I will really need you folks to do is to come prepared for the tutorials, because my tutorials are really quite interactive. And the best thing about the way that I rip apart the tutorial problems that you've got to watch is that we get to actually try and together nut out an IRAC answer for each problem question. And that will give you a bunch of practice then for your take-home paper. So we can't really do much of that if you folks haven't really digested the law yet. Okay, so I'll pitch it how I can and we'll run through it, but can you just make a mental note for next time? I really do need everyone to get across the materials, because it's this whole tutorial thing and flipped learning is really meant to be an active exercise, because there's just a bunch of studies that show that active participation, and in particular problem solving, so you've gone through the materials and then your brain confronts the problem, and your brain's got to kind of sift through everything that you've just digested and work out, well, where does this fit to answer this problem and where does that fit to answer the problem. When your brain's forced to engage like that, that's when the deep learning happens, okay? And with contract law, the reason why it's in first year is because it really does cut across so many other of your following units in your degree studies. So it's foundational. And it's not one of those units where you can just kind of do it and then kind of toss your notes out the window because you're not going to need them again. Contracts, as you know already, you encounter them every single day. And, you know, I can tell you right now, when I was in practice, a lot of the disputes that we used to get were disputes around these kinds of vitiating factors, and in particular, whether or not a person had the right to rescind, and Peter will take this with you later on in about week 11, I think it is, the rights of termination. This stuff will come across your desk all the time if you intend to practice. And so it's super duper important that you approach these tutorials kind of armed and ready to go, so that you're getting the most out of the tutorial and the most out of our time together that you possibly can. Let's face it, you're paying an absolute bucket load of money for this unit, so you might as well get the best out of it. This is our only opportunity to interact live face to face. So yeah, it's really crucial that we all come together next week, ready to go. I'll pitch it, you know, how I can. But if you folks haven't actually had a chance to confront the materials, it might just all kind of go over your head a bit. Don't worry too much, because I release all of these answer guides for you, but obviously they're not meant to be a substitute for going through the videos and going through the study guide and reading law. Just as a link, sorry, just had somebody pop through here. Sorry, small interruption there. So litmus test here. Can I just take a temperature check? Who has been managing to, generally speaking, keep up with your materials? This is just can I have a 1 in the chat box if you, most weeks you have today been keeping up, or 2, most weeks you've just kind of been winging it with Peter. Okay, so I've had some people saying that they've been keeping up. 1.5. This is not a wag the finger exercise. I'm just saying, you know, I do feel sorry for a lot of you, because I know a lot of you do work full time, and it's really hard to find the time to get across everything in time. And also, you've just had to hand up your assignment, haven't you? Yeah, right. So I understand that usually the week after assignment is your catch-up week. Well, it used to be for me. So this is probably just a bit of a blip on the radar, but next week we'll get cracking on it. So void contracts, they are these little beasties, void. I'll do that in green. And you can have contracts that are void at common law and contracts that are void via statute. And probably one of the best examples of void contracts by statute is Section 64 of the Australian Consumer Law. Has anyone heard of the Australian Consumer Law before? Yes, one in the chat box for yes, two for no. Oh, hooray! Has Peter told you about it? Or do you just know because you're excellently fabulous people? I want to see in the chat box, oh, it's because I'm excellently fabulous. All right. Okay. So some of you do know about the Australian Consumer Law. The Section 64 of that says that if you try to contract out of any of the consumer guarantees, you know, like whenever you buy something from Aldi or any retailer, you know, Myers or David Jones or whoever, then it's going to have to be things like fit for purpose. And if it's been sold to you by description, it's got to correspond with the description and all of those things. And if you try and make a contract and in the contract you say, oh, and by the way, we're purporting to exclude or limit as far as possible any of the Australian consumer guarantees contained in the Australian Consumer Law, then that will render that provision void. Okay, there was a great little case on that not so long ago. Under common law, we have three areas where a contract might be void: contracts in restraint of trade, contracts that oust the jurisdiction of the court, and clauses, this is an odd one. We've got some odd ones this week, folks. Clauses prejudicial to marriage. And can anyone explain for me what contracts in restraint of trade are? Have you ever heard of a restraint of trade? No? Okay. Well, a contract in restraint of trade is, let me just go back up here. It is the kind of clause that you might commonly find in employment contracts. Now, if you folks haven't really done much reading, what I might just do is bring my answer guide across here and we can just look at that. Okay, so here, contracts in restraint of trade. Generally speaking, as I said, you find these little beasties in employment contracts, and they will say things like, for a period of 5 years after employment, Joe Bloggs will not work as a lawyer, for example. And that is a restraint on your trade, okay? So the court looks at that with a fairly strict eye, and obviously because they don't want people to be out on the streets paupers, they don't like the extinguishment of one's ability to make a living. So they will be prima facie void, as you can see there. But if you want to try and enforce a restraint, there are ways that you can go about it, okay? You just got to rebut the presumption that the contract is void. And how do you do that? You show that the contract is reasonable in the interests of the parties and reasonable in the public interest, okay? Now, I won't bother you with all of the law around that, but what I will say is that where you are selling a business, for example, a court is likely to look at restraints of trade a little bit more gently. How can you look gently? That was a good mixed metaphor. It will be a little more friendly towards such clauses because why? Can you think of why? If I'm selling you a $1 million business and I put in my contract that you're not to set up that, sorry, and you as the purchaser want a clause in there to say that I'm not going to just sell you the business for $1 million and then all of a sudden set up across the road again and have all my old clients come back to me. Can you see how the court will look at that arrangement a little bit more in a more relaxed manner? It's really a protection for that purchaser that they're going to get the value of what they've paid for that business, isn't it? So it's not really the same as where, for example, you're Mr. Mean and Nasty solicitor who's the principal of a practice and tries to stop poor little Joe Bloggs from practicing as a lawyer for the geographic distance of 5 miles around the practice for 5 years after they've left. Okay, so there's a lot of law that goes in and out of restraints of trade, and law discusses restraints of trade at page 492. Okay, so have a little look at that. Of all of the void contracts at common law, that is the one that you will get across your desk most regularly in practice. Restraints of trade. Sometimes restraints of trade in business, but more often disgruntled ex-employees that don't like their restraint. Okay. The other one is ouster, where you attempt to oust the jurisdiction of the court. Does anyone have any idea of what that's about? No. It's where you attempt to put a clause into the contract that restrains the parties from going to court in the event of a dispute. Okay. Now, why do you think that policy would dictate that you can't have that kind of clause? What's the whole point of a contract?
Would it be taking away someone's right?
Exactly, Jasmine. Exactly. The whole point of a contract is to have a way to legally enforce whatever it is that you're exchanging promises about, isn't it? Otherwise, why would you bother with a contract? You just do a pinky promise. You know, the whole point is to be able to go to court if something goes wrong. So it really undermines the basis or the fabric of the contract if what you're trying to do is say, well, we're creating a legally enforceable contract, but if there's a problem, well, you can't run off to court. It's kind of like a misnomer, isn't it, really? So, but there are ways that you can get around that. And I will leave you to explore those. And they are at 489 of Gore. Then we have clauses prejudicial to the status of marriage. I'm not even going to go into that one. It's so rare nowadays. It's rarer than hen's teeth. And you can kind of put that one on the shelf. Then we come to illegal contracts. I might just make this a little bit bigger so that you can see this a bit better. Is that a bit better? Okay, so we have a number of situations where again common law will declare a contract illegal. So this is contrary to public policy, and contracts that are contrary to public policy will be illegal, and therefore they will have the consequence of extra causa. Okay. So there's the bunch, the ragtag bunch of elements there that will, you know, cause a real problem for you if you have them in your contract. Contracts to commit a crime or tort. So obviously, contracts to murder not going to be enforceable. Contracts to commit a tort. That is what's a tort that we all know and love? Willful negligence. You can't contract, you know, to do something like that and expect to have it enforced. Contracts to defraud the revenue, so tax evasion. Contracts prejudicial to the administration of justice. Contracts tending to corrupt public officials. Prejudicial to national security. Obviously, if you are going to sell a national secret, you can't expect that contract to be upheld. And contracts promoting sexual immorality. Look, that one is much like the other one, never really used much at all, although there was a reasonably recent case on that with spectacular success, but generally speaking, that one's just gathering dust on the shelf as well. So do go and have a little look at those. They are in GRAW 474 through to 480. Okay, then we've looked at extra causa, illegality by statute. So this is where the express words, remember the first one we had a look at was void contracts by statute. And that's when the statute itself says, don't do X or your contract will be void. And it actually uses the word void, okay? Illegal contracts under statute are when the statute says, don't do X, period, or X is prohibited. Okay, contract, in fact, even better, contracts to do X are prohibited. And that will have the consequence of illegality and therefore extortion. Okay. Few interesting cases here. Baird and Magroupolis. That was an older case where you had, as it says there, the defendant leased land from the Crown and it was subleased to two, I really feel sorry for these plaintiffs, Greek men who could speak little English, and the Leases to Aliens Restriction Act. How about that for the name of an act? You'd never get away with that nowadays. Leases to Aliens Restriction Act said it's not going to be lawful to enter into any agreement for any lease of any parcel of land with any alien who has not first obtained a certificate that they're able to read and write from dictation words. Any agreement shall be null and void. So there you have an expressly illegal contract. This here, don't worry about this because that doesn't add anything to it. This is something that you really need to pick up on. In this area of law, there is a lot of confusion about terminology, and that's why I started the whole tutorial with terminology. You have to be crystal clear about what a void contract gives you, doesn't give you, whether it will pass title, etc. And you have to know and distinguish how that's different from an illegal contract. And here, the addition of the words null and void, the fact that it says up here it's not lawful to enter an agreement means that it's illegal. You can't make it any more illegal by saying, oh, and by the way, any such agreement is going to be null and void. Because just by saying it's not lawful means, bang, you've got the consequence of ex turpi causa. Okay, but often in decisions, you'll even see judges writing that this contract is illegal and void. But void doesn't add anything, because you can't, you know, it's like being dead. You can't be any more dead. Okay. So Baird and McGripplis, he had leased, these poor little people had leased the land, but they couldn't speak much English. The sublease depended on either passing the test or becoming naturalised. They became naturalised, okay, so they've complied with the conditions of their sublease. The problem was, can you just shut that door for me, please? The problem was that the legislation said it was not lawful to even enter into the agreement without the alien first obtaining a certificate that they could read and write from dictation, right? So it's no good in your sublease then saying, oh, everything's going to be sweet if you can either pass the test or become naturalised. Poor little people just became naturalised, and then all of a sudden the other party want to back out because they're saying, well, actually this contract is inconvenient for us. We don't want it, notwithstanding you pumped out all of this money into the property. We want to back out of the contract. We are saying it's illegal. Why is that? Because the statute says just becoming naturalised is no good. You had to have actually passed that dictation test before we even entered the contract. Okay, and the court said, yes, that's right. The contract was void. So often, as I said to you before, illegality will be used as a way to try and back out of a contract. Mahmood and Isbahani is mentioned in Graw, and also Pham and Doon. Similar kinds of principles there. Implied illegality is where you have an act not specifically saying here. So in Baird and McGripplis, couldn't be any clearer, could it? It's not lawful to enter an agreement. Okay, so you can't make the contract, otherwise it's going to be illegal. All right, very crystal clear. With implied illegality, what you'll normally have is not that level of crystal clarity. And you will have an act saying it's prohibited to do X. And then the question becomes, is a contract to do X illegal? Okay, so the act prohibits the act, prohibits the conduct, but it doesn't say anything about contracts that involve that conduct. So what you've got to do is a little bit of a forensic process. And you've got to look at the legislation and you've got to work out here the object of the statute, the purposes of the statute, and the wording of the prohibition. They're going to be the boundaries of your investigation, okay? And you have to get to the bottom of what the act is actually trying to stop. And then once you've got the answer to that, the object and the purposes, then you can go to the provision itself and say, okay, let's have a good look at that prohibition. It says that you mustn't do X. What else does it say about that? Is there a really severe penalty? Is there jail? Or what's the story with doing X? That will give you some guide about the seriousness that Parliament has placed upon the doing of X. Okay. Then you've got to look around at what's happened on the facts, and you've got to say, is what the parties are contracting to do, is that likely to undermine the purpose of that legislation? Okay, and you'll often find this kind of thing being found, this kind of contract being found illegal particularly where you have issues of public safety at stake. Okay, so that was the case in Pretorius and Muir. In that case, we had the Therapeutic Goods Act prohibiting the selling of prescribed therapeutic goods unless you were licensed. So that's how they kept tabs on everybody that was going to be selling these therapeutic goods that may or may not seriously harm the public. If the seller didn't know what they were doing, there was a serious issue of public safety at stake. So typical thing, the unlicensed seller sold goods, then those goods were subject to the Therapeutic Goods Act. Interestingly, the purchaser didn't pay, but the unlicensed seller stupidly sued for recovery of the payment, and obviously failed because the contract was impliedly illegal. The Act had severe penalties, intended strict and rigid control of the goods. Makes sense, doesn't it? So often in that kind of situation, you will have it fairly easy to be able, easier to be able to establish illegality, implied illegality via statute. Where it gets a little bit more difficult is, you know, like purely commercial circumstances. And that's where the case of Yango Pastoral comes in. And I will leave you to have a look at Yango for yourselves. Yango is, let me have a little look here. Chapter, well, 14.150, 153, 160 of law. Okay. So that's Yango. And the last but not least is a legal purpose. Okay, and a legal purpose, what happens here is the contract, is the statute doesn't say it's unlawful to enter an agreement for X. That would be express illegality, wouldn't it? It doesn't say, the statute doesn't say it's unlawful to do X, and then you've made a contract to enter into it. That would be implied illegality. So it doesn't do either of those things. But the Act sets up a norm to be enforced by the courts. And the argument runs that even though contract doesn't, the statute, sorry, get it right, even though the statute doesn't expressly or impliedly make something illegal, nevertheless, what is proposed to be done by way of contract would contravene the norm set up by that legislation. So it's a bit more grey. So the most clear tier, if you will, of statutory illegality is express, obviously. Implied illegality, yeah, a little bit more fuzzy around the edges. You've got to do a bit more digging. Illegal by way of furthering an illegal purpose is more fuzzy again, and you've got to do more digging. And it's the same kind of digging that you do for implied illegality. So what you've got to do is you really got to get a very thorough understanding of the object and purpose of the legislation that you're arguing about. Okay. There's a case that Graw looks at, which is Equus Corp. That is a commercial case. This Fitzgerald and Leonhardt, I like this case because it's a dispute between individuals, a person that wanted some bores drilled on his property and the person that did the drilling. And this was up in the Northern Territory obviously water is in fairly scarce supply. Well, not at this moment, but it was then. And the Water Act required bore construction permits before you actually went about drilling your holes to create the bores. They needed to know who was drilling holes for bores and what the likely impact of that would be for water supply in the area, obviously. So a fairly serious matter here that is being legislated on. As I said, the owner contracted with the driller. The driller was licensed under the Water Act, but the owner didn't get the necessary permit that he was supposed to before the driller came onto his property to drill the holes to create the bores. The poor little driller did the work and sued for payment. The owner alleged that the contract was illegal. Now, the Water Act didn't say a contract for drilling holes to construct bores without a necessary permit for the owner's land is illegal. So it wasn't express illegality. The Act didn't say it's illegal to drill for bores on an owner's property if the owner doesn't have a permit. So that would have been implied. Actually, no, that would have been expressed. What's a better example? Oh, no, that's right. If it said it's illegal to drill holes on a property where there's no license, then a contract to do that conduct would be impliedly illegal. But what the Act did do was that it set up this norm that water's a precious resource, we have to control it properly. There was this whole system of permits and licensing. And so the owner didn't want to pay, said, oh, well, I didn't get the permit for you to drill on my property, so the contract's illegal. I would encourage you to go and have a look at this case because it really is quite entertaining and a very good example of nice, clear judicial exegesis. Nice descriptions here, very plain English and easy to read. But as you can imagine, the court didn't take it very kindly to the owner trying to get the work for free and failed. But there's a very good description of how you go about working out if something is illegal because the contract is in furtherance of an illegal purpose. Okay, do you have questions about that? The difference between express illegality, under statute, implied, and in furtherance of an illegal purpose? Clear as mud? Good. Okay, what we can do is just very quickly go to the problem and watch it and have a couple-minute discussion on just some general thoughts on how you would have gone about answering that. Okay. Where is the tutorial? Oh, tutorial 8. Hang on a minute. Oh, do we not have? Odd. Ah, there we go. Is it not opening? There we go. What? How very odd. Has anyone watched the little vignette?
I was able to watch it. It just took a while to come up.
Oh, did it?
Yeah.
How odd. You know what I'm going to do? I'm going to go to my contracts Moodle webpage that I ran last time around, and all the links are here. Easy peasies. There we go. All right, illegality. There we go.
Welcome, Peter. Please come in and sit down.
Thanks, love. What did you say your name was again?
My name is Julianne. I am one of the solicitors here. How can we help you?
Well, it's like this. I retired about 2 years ago. Used to be a foreman in a factory down in Victoria. This is back when Australia still made cars. You see?
Sure.
Anyway, I decided another Melbourne winter was going to kill me. So I moved to Queensland. Decided to buy a hobby farm. Found out that hobby farms are boring. Fruit trees just sit there and do nothing.
I guess so.
So I was in a doctor's surgery and I read an article about Aquabra. You know, the hat company. Turns out they make those hats out of treated rabbit pelts. But they go in growth because this new virus is killing all the rabbits in their warrens. It's saving the farmland, but killing the hat company. I thought to myself, here's an opportunity. I've got a farm and they need rabbits.
Did you actually farm rabbits in Queensland?
No. Turns out it's illegal in Queensland. You can't even keep them as pets. So I couldn't farm them.
Thank goodness for that. I thought you were about to tell me you've been charged.
No. It would be funny if I though. I could be the famous outlaw rabbit keeper, a fugitive from the law. I could even have a costume with an Aquabra hat.
Oh dear. So if you didn't get charged, what did happen?
Well, before I found out about this ridiculous law, my plan was to farm rabbits for a profit. So obviously I needed a supply contract. I got in touch with a fur wholesaler and contracted with him to supply 1,000 pelts a year for 3 years. It was easy. Like I said, they are finding it really hard to obtain pelts.
Did the wholesaler know you were in Queensland?
He didn't ask, and I didn't say. Anyway, once I found out that farming rabbits is against the law, I went back to him and said we'd need to cancel the contract. He refused. He told me that I'd made a deal and that he has already on-sold the pelts for the next 3 years. He needs them delivered. So here I am with a contract to deliver 3,000 rabbit pelts while my hobby farm is in a place where rabbit farming is illegal. Can you give me any advice?
Yes. My advice is that you should see a lawyer before committing yourself to a contract next time. But I will see what I can do to help you for now.
Oh dear. A little bit of sarcasm with clients. That's probably not the best way to go, really, if I'm honest. Okay. So, all right. What does the contract require? Rabbit pelts. Well, I'll put you on your toes because you've seen this now. I'll get my other one back up here. The legality form. All right. It requires rabbit pelts, which are dead rabbits that have been skinned. Keeping rabbits is illegal. He's retired, moved up here from Victoria, bought a fruit tree farm, thought that was boring, read about Aquabra hats, thought he'd be able to make a bit of money. So he had a farm, they needed rabbits, but he found out that keeping rabbits is against the law. He didn't farm the rabbits and he wasn't charged for rabbit farming, but he made this contract, a supply contract, and he offered to sell someone 1,000 pelts a year for 3 years. The offer is to supply pelts, which are not prohibited, not to farm rabbits, which is prohibited. So he did the contract, then found out about the illegality issue, realised he couldn't farm the rabbits, wants to back out. The fur wholesaler says no, he's made a deal. He needs the pelts because he's already on-sold them. Right, so he's going to want specific performance of that contract. What is specific performance, by the way, peeps? Specific performance. Anyone know?
Is that where the court orders them to do what they said they were going to do?
Yes, exactly. So he's going to stick up his hand and ask the court to order that Peter be specifically, that Peter specifically perform the agreement. Peter has contracted to deliver the pelts, but obviously he's in a pickle now. What are you going to do? How are you going to pull it out for me, pull out the various different issues? We know that the problem is, or the issue statement is, whether Peter's contract with the fur wholesaler is illegal and therefore can't be specifically enforced. So that will achieve what Peter wants, because he wants to back out of the contract, doesn't he? Okay, so that's your issue statement. Your rules will be, as we've discussed above, for statutory illegality. So how would you start off an IRAC like this? What would you talk about first? Let's just do some bullet points, because we'll move on to mistake here. You can have a look at my full answer guide. It's about 7 pages long, so it will answer any questions that you've got. But just play around for a couple of minutes with how you would kick this off if you were writing an IRAC.
I would talk about contracts that are illegal under statute and how this particular scenario fits into those express or implied.
Yes,
Yeah.
absolutely. Yep, that's exactly where you start. So Peter wants to be able to avoid the contract. He'll want to argue illegality. If the contract is held illegal, now let me just copy and paste here. There we go. He'll want to argue illegality. And what you're trying to do is impress the marker with your knowledge of this area of the law. So you're showcasing what you know. If the contract's illegal, the consequence is extra causa. Okay. No cause of action arises out of the base case, which means not only will the fur wholesaler be unable to enforce the contract, he won't be able to recover any monies paid over to Peter. So this is a double whammy, a double benefit for Peter, our client. Okay, several ways for a contract to be found illegal. Maybe by way of common law or public policy, although the facts here don't fit into the illegality by common law, do they? It's got nothing to do with that really. All you're showing the marker there is, you know that category exists. Alternatively, a contract may be illegal by a statute. It might be because of one of these 3 reasons. Then, what would you say about express illegality? Is it a case of express illegality? What is the nature of the problem? What does the Act say?
Would it be more implied illegality because it's not like against the law to have the pelts, it's just against the law to farm the rabbits.
Is it implied? So what explain implied then? Just give me a 25 words or less.
Kind of confused myself. I just have to like regather my thoughts.
Okay. So express is if the Act had said, you shall not enter an agreement to supply pelts. That would be express. If it was implied, it would be something like it's illegal to possess pelts, and therefore it would be implied that contracts to sell pelts are illegal. If it is a contract in furtherance of an illegal purpose, it's that the legislation doesn't say either option A express or option B implied. It just sets up this vibe, to use a very Marbo / the castle term, and the object and purpose of the legislation is all about controlling and prohibiting things that the contract involves. So remember I said express is the clearest form. Implied, a little bit more fuzzy. You shall not do X, but it doesn't say you can't contract to do X, or you shall not have X, and the actual conduct was contracting to have X. That would be implied, or then you've got illegal purpose. So if this was a case of implied, the legislation, as I said, would say you mustn't possess pelts, and therefore contracts to buy and sell pelts would necessarily be impliedly illegal. The statute hasn't exactly said you can't contract to buy and sell pelts. It's just said pelts are naughty. It hasn't specifically said you can't contract about pelts. So is that a case? Is that the case here? Did the legislation say, no, you can't keep pelts?
I thought it was more to do with being illegal to farm rabbits in Queensland.
That's exactly right. It said you must not farm rabbits. So it's not express, it's not implied. So we have to, the only option it could be is in furtherance of an illegal purpose. So in order to work out whether it's going to be illegal for furtherance of an illegal purpose, you would have to be able to read the legislation to give a proper view on this. Okay, so how would you go about answering this in a take-home paper? What you do, it's all about working smarter, not harder. Clearly, you don't have the legislation, do you? So you can't give a conclusive view. What you can do, again, is, like I said, show the marker that you know your stuff. So with express illegality, you would just be saying, well, let's just work out by process of elimination what this is. Is it express? Well, you tell the marker, I know what express illegality is. And you give a little case, little bit of case mastery there. Here's a case, I really do know what this means. Here, it seems there's no issue of express illegality because the legislation that prohibits rabbit farming, it doesn't expressly prohibit the sale of rabbit pelts. Okay, all right. So now let's look at implied. Is it a case of implied illegality? And no, it's not a case of implied illegality. There might be circumstances where a contract's not expressly prohibited, but it might prohibit conduct and the contract might require performance of the conduct. Then it's going to be impliedly illegal. Again, here, you just give a little bit of case mastery. I really know what I'm talking about because here's an example of these couple of cases here that talk about implied illegality. And then you do your application. So that's why this is called the application section. You apply the law to the facts. Here, we're told that the Act prohibits rabbit farming, but there's nothing that requires Peter to keep live rabbits. It's simply, the contract's simply about pelts. So it's not like the decision in Pretorius, that Therapeutic Goods Act case that I told you about. It doesn't seem like it's going to be impliedly illegal. Then you would go through public policy and furtherance of an illegal purpose. And like I said, it doesn't actually give you the legislation to be able to work out whether or not this thing's going to be in furtherance of an illegal purpose. So you would just discuss the general requirements and procedure that you go through in looking at whether or not this could potentially be a case of furtherance of an illegal purpose. And you probably discuss the Leonhardt case, which I talked to you about before, that Water Act case. Okay. I did do some digging if anyone has a burning need to know. The actual legislation is the Biosecurity Act of 2014, just in case anybody really, really wants to know. And it does actually make keeping rabbits illegal. You can read up on this in the answer guide. But again, if you had the Act in front of you, you would come to the same conclusion. There's nothing in there about pelts. Okay, so rabbit pelts don't pose the same kind of biosecurity risk as live rabbits do. They'd fall outside the object and purpose of the legislation, and therefore the contract would still be valid. So I think at the end of the day, dear old Peter would be stuck with his contract. Does that make sense? Yes, 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 yes. Can I have a 1 in the chat box?
Yes, it does.
All right, that's good. Do you have any questions? I appreciate that the different shades of statutory illegality can be a bit confusing, but I think once you've had a chance to kind of have a look at the answer guide, go through the materials, I think it'll be a little clearer. Anything before we go to a break? No? Okay, let's meet back at 7:20 and then we will go through mistake. Okay. Hey ho, everybody. Welcome back to the back half of our tutorial. And once again, I will share my message screen. All righty. And what's that one? Let's just get rid of that one. All right. Let's get cracking on mistake. Okay. For common mistake, Common mistake. How many parties are suffering under the mistake? You can answer in the chat box or just open mic.
I'm not sure if I might have actually read a tiny bit of this. Is it
Hooray! Lecturer rejoices.
is it where both of the parties have made the same mistake?
Absolutely. Hooray. Hooray. So there are all parties are suffering under a mistake. How many mistakes have been made? One, because everyone's making the same mistake. Okay. They suffer under the same mistake. Okay, 4 types of common mistake. Some lovely little Latin phrases again here, folks. So common mistake as to existence of subject matter. Anyone? For the Latin, 10 bonus brownie points if you can get the Latin name for this. Race.
Is it I'm tongue-tied now.
That's it.
Extinctor?
That's it. 10 brownie points. Race extinctor. Now, if you have a case of race extinctor, both parties are mistaken that the subject matter exists when it actually doesn't. Which is kind of a silly mistake to make, but anyway. What is the result? Void, voidable, unenforceable?
Would be void because they both made the mistake and it just doesn't exist at all.
Yes. At common law,
Yeah.
makes sense, doesn't it? Now,
Yeah.
equity follows the common law. So equity is this great little body of law which it's like the white knight that rides in to save the day when the black-hearted common law has made this really strict decision about something usually. And equity sometimes just has to follow along behind the common law. Sometimes, if there's good reason for it, and we call that the jurisdiction for equity being enlivened, if that happens, sometimes equity can overrun common law and provide you with a different remedy or a different result. But here, both parties think the thing exists, it just doesn't. It's just void, okay? Equity follows the law. In terms of common mistake as to title, we call that race what?
Sewer.
Woohoo! Who was that? Was that Dion?
Yeah.
Love it. Good on you, Dion. Okay, so it means the thing what was not
Already
well, it's
already is, but not
non-inclusive
yeah,
language
sort of like,
here. The thing was not, they say the thing was not his, but I like to say the thing was not theirs.
yeah.
So it wasn't theirs to give and it wasn't theirs to take. So, okay, so the thing wasn't theirs. The result for that at common law, what? Void.
Void.
Yes. And again, here, equity follows the law. Okay. Then we have common mistake as to subsisting circumstances. Now, Braw doesn't look at this one, but there is a great, in the study guide, I tell you to look at Wilmot. It's in the Wilmot text, 14.97. So this was a nifty little circumstance. The case here is Griffith and Brymer. And both the parties thought that the King's, this was back in 18 something or other, when I think it was King George was about to be, his coronation procession was about to happen. And there was a contract that dealt with looking at his procession going by. So if someone wanted to hire a room to look at the procession going by, it had been announced that the King had got appendicitis before this contract was made, and that the procession was going to be cancelled. And neither of them knew about it, made the contract to buy and sell the hire of the room to see the procession. But of course, there was no subsisting circumstances. The procession actually wasn't going to be happening. And since the procession was the foundation of the contract, it was held that there was a common mistake as to subsisting circumstances. And in that case, at common law, it's void, the odd void, and equity again follows the law. Last one, common mistake as to, now this is a tricky one. Okay, what's the result here? Contract is valid.
Is
valid
Oh.
at common law, and equity. Yeah, this area of the law is a bit of a mess. So here, I'm just going to copy and paste over here. So we have this little case called Bell and Lever Brothers. And in that case, that was a mid kind of 20th century case. And that one's fairly strict, and it says there's only a couple of cases that you're going to actually have a void contract: res extincta and res sua. So this one doesn't even get mentioned. These two are definites, okay, but it says the only other thing that might render a contract void at common law is where the mistake makes the thing without the quality essentially different from whatever it was believed to be. Essentially different. Okay, so if the mistake really makes it something quite radically changed, it might be void. But other than that, it's going to be valid. Now, then we had a case by the name of Soleil Butcher. Now, have you folks read any of Lord Denning's judgments yet? Lord Denning was the guru of 20th century decision making in the UK. And he decided Soleil and Butcher. And basically he was thumbing his nose at the judges that had decided Bell and Lever Brothers. And he said, well, you know what? That's actually not the case. If you have a common mistake about something, if it's a mistake about facts or rights that are of a fundamental nature to the contract, and there's no fault, no naughtiness involved, then it will be voidable in equity. Okay. Bell and Lever, very harsh decision here. They say it's only these two that make the contract void. Otherwise, it has to be something essentially different. Solly and Butcher says, well, actually, no, that's not really the case. It might still, even if it's just one of these and not one of these, it might still be voidable. You might be able to back out of the contract if it's a mistake as to subject matter. Then we had some pretty harsh decision making in the UK that overturned Solly and Butcher. And that was the case of Great Estates. Great Peace. Australia Estates was the Australian case afterwards. Great Peace found, and they basically said this case here was overturned. No longer good law. Okay, they went back to Bell and Lever Brothers and they said, not only did it have to be radically different, or whatever they called it, essentially different in order to qualify to be void, but the contract had to be impossible of performance. You couldn't actually be able to perform the contract because of this mistake. So there was 5 elements in order to get a contract declared void. It was some common mistake as to the state of affairs, no warranty by either party that that state of affairs existed, no fault, it renders the contract impossible to perform, and the mistake has to be the existence or vital attributes of the consideration to be provided or the circumstances which must subsist. Okay. Now in Queensland, we follow that strict decision of Great Peace. But interestingly, there's other states in Australia which have preferred Solly and Butcher. So it's all, as I said, a bit of a higgledy-piggledy mess at the moment. And have a look at my answer guide if you have any queries on that. Okay, so that's common mistakes as to the subject matter. The reason why courts are so reluctant to let you back out of a contract for a mistake on subject matter is, so mistakes about subject matter are things like character, quality, value, etc. So if people could too easily back out of contracts just by saying, oh, hang on a minute, well, I paid $5,000 and they told me it was going to be blah, 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 and now it's not really, I don't think that's proper value. You can see it would open the courts, the floodgates to the courts just being clogged up. Contracts really have to be very certain, and the avenues to get out of a contract have to be very restricted in order to promote commercial certainty. So they can't let this doctrine of mistake run away with the certainty of contract law. Okay, so all of these types of mistake are quite difficult to establish. But that one in particular in Queensland is really not possible anymore. Okay, so that's the types of common mistake. Mutual mistake, okay. Many mistakes made mutually. How many parties are suffering under a mistake? If it's a bilateral contract, How many parties? Yes. Okay. And so we have two different points of view, but then maybe how many mistakes? Ooh. Ooh, what does that mean?
If
Okay.
they've made the same mistake or different mistakes.
That's right. So if they've made, no, it might be one mistake that's been made only, and the other person is correct in their interpretation of the contract, or they might be both mistaken, or you can't tell. Okay, so what's the classic case here? What's the classic case in this area of the law? Raffles and Wigglehouse. Raffles and Wigglehouse. So at common law, if objectively you can't make sense of the agreement, the contract will be void. And in Raffles, we had a contract saying that the goods would be shipped ex Peerless from Bombay, ex Peerless. So the goods were to be consigned onto the ship Peerless, departing from the port Bombay. But the problem was that there were two ships called the Peerless. One was to be leaving in, I think it was October, and the other one was to be leaving December. And there was no real way to work out from the face of the contract which ship was designated. Okay, in that circumstance, the court can't work out what, obviously one party is saying, oh, I meant October, and the other one saying, no, I meant December. On the face of the contract, the court can't work out what was meant, and so it's void. Okay. If the court can work out a meaning, it might mean that that particular meaning that the court finds aligns with what one of the parties thought. Now, if that's the case, it's just one other party that's mistaken, isn't it? One party's view was reasonable, one party's view was not. Okay. In that case, it's going to be valid that according to the correct party that has the correct interpretation that aligns with the court, and that's how the court will construe it. Okay. In true mutual mistake, neither one knows about the other one's mistake. So there's no naughtiness here. There's no need for equity to intervene. So equity just follows the law. If the law says it's valid, it'll be valid. If the law says it's void, it'll be void. The jurisdiction for equity to intervene has not been enlivened because there's no naughtiness here. A unilateral mistake, again, we have to be upfront about the fact that objective theory is used. So unilateral is where only obviously how many people are mistaken.
One.
Yeah, uni one. Okay, so the contract will normally be valid at common law. Just because one of the parties is subjectively mistaken about something that the contract says, if the contract's clear on its terms, that's how it will be enforced. So in Taylor and Johnson, where poor old Mrs. Johnson, I think it was, and Mrs. Taylor, I forget, the party that was mistaken, the contract actually said that she'd be selling her land for a total of $15,000, but she thought that Mr. Taylor had offered her $15,000 per acre, which meant that she was going to be missing out on about $90,000 worth. Now, the contract itself was very clear. So at common law, that contract would have been enforced. The interesting thing is that there was naughtiness involved in that case, and so equity was able to step in. Usually, though, unless if there's no naughtiness, the only exceptions will be mistaken identity and non est factum. Another lovely little Latin phrase here. So mistake as to identity, and this is relevant for the little tutorial problem. The elements are that party A who is mistaken only intends to contract with, a particular party. That identity is material or important to party A. A intended not to contract with the person that they've actually contracted with. They intended to contract with C. B knows it. If that's the case, it's going to be void at common law. Now, interestingly, there's a couple of little distinguishing factors here according to whether the contracts were concluded by writing or whether it was face-to-face. If contracts were concluded by writing and you can satisfy, your client can satisfy these elements, then it's just going to be void at common law. And with contracts concluded face-to-face, it's easier because it's easier if you're trying to keep the contract. It's harder to get out because there's a presumption that you intend to make the contract with the person in front of you. The person that's in front of you, that is inter praesentes in Latin. So if the contract is one inter praesentes, face-to-face, inter praesentes, there is a presumption that it's your hard luck if you've mistakenly identified the other person that's right in front of you as someone that you actually, somebody else that you thought you were contracting with. The law says, well, you're silly enough to be right in front of them and still be mistaken about identity. No, we're not going to protect you in that circumstance. And so you're presumed to have intended to make the contract with the person that's right in front of you. And you have to rebut the presumption by showing that you took sufficient steps to work out if the person right in front of you was in fact the person that you only intended to contract with. Okay. Non-est factum. Non-est factum is a funny little area. And it's all about protecting people in a particularly vulnerable situation. So relevant class of people is usually people that are dependent on the person that they're dealing with to be transparent. So people that are blind or that have language difficulties, for example. So there's a relevant class. They have to have signed the document in belief that it was radically different from what it was. And if the other person was actually innocent, like there's no naughtiness going on there, then the claimant's failure to read the document mustn't have been due to carelessness. So in Peatland and Cullen, that's a good example. This poor little person couldn't really speak English, and the nasty swindler presented a document and told the person that it was just a receipt. Please sign this receipt. They signed, and you guessed it, the document was radically different from what they thought. So therefore, non-est factum, and you can get out of that contract. Okay. Unilateral mistake as to substance is another difficult area of law, pretty much like unilateral common mistake as to substance. You know how I said there's these cases, you've got Solé and Butcher on one hand, you've got Great Peace on the other hand. We don't really know. There's been no high court guidance on which one we're really meant to be following. Different states are doing different things. So it's a little bit, it was a little bit like that in this area also. And then we had Taylor and Johnson, which is that one that I was talking about before up here, where poor old lady who was selling her land was swindled by the person that represented, things that were different than they actually were. So the elements for unilateral mistake as to subject matter, there has to be here, this is from the case of Taylor and Johnson, okay? A serious mistake about a fundamental term of the contract. The other party is aware or has reason to be aware that the first party is under that mistake, so they know that the other party is mistaken, and then they deliberately set out to ensure that the first party doesn't become aware of the mistake. Okay. Oh, goodness. Okay. So in Taylor and Johnson, of course, they could satisfy all of those elements. The poor old lady was under a serious mistake. Obviously, $15,000 total for selling all of your land is a lot different than, 100 and whatever it was, $1,000. The other party knew that she was under this mistake of thinking that the contract said it was going to be a lot more than it was. And how did the court know that? Well, it said that the party deliberately avoided talking about the sale price. And they actually, Mrs. Johnson said, oh, look, have you got a copy of the contract I can just take home and read before I sign? And the other party said, no, I don't have a copy, when they actually did have a copy. So there was all sorts of shenanigans going on. She didn't have her glasses. He says, go and just sign. She signs, and the rest is history. So she successfully, even though that contract would have been valid at common law, because of its face, the contract was very clear. This is a sale of land, $15,000, but equity could step in because of this reason I've highlighted here, and this. So the equitable jurisdiction was enlivened, even though valid at common law, equity says, no, sorry, it's voidable. Okay, so that is unilateral mistake for the subject matter. Now, if we have a little look here at the oh, come on, there we go. Little mistake.
Please have a seat. Mitchell.
Actually, I'm generally known as Lord Mitchell of the 7 Golden Orbs, but you can just call me Mitchell if you wish.
Thanks. Do you have a legal problem I can help with?
Indeed I do. No doubt you would be aware that the author Jordan Roberts has recently completed the most recent Wheel of Thrones book. It's called On the Limb of Prophecy. Have you read it yet?
Actually, no, I haven't.
You love it when you do. It's his best yet. Anyway, recently I found out that Jordan Roberts was going to do an impromptu book signing right here in town. Did you know that?
No. Somehow I didn't hear about it.
Seriously? You missed out. Anyway, the book signing was meant to be at 10 o'clock, but at the last minute I couldn't find the jewel scabbard for my sword of justice and heritage. I wanted to go in costume, you see.
I'm sure that was very impressive.
You know it. Anyway, with the delay finding my scabbard and the fact that the digital watch just wouldn't go with my warrior costume. I lost track of time and I arrived just after the book signing had finished. I was devastated.
I'm sorry to hear that, Mitchell. It must have been disappointing.
Yes, but all was not lost. Next thing I knew, some guy was waving to me from a nearby coffee shop. He was in his late 40s, had a beard, dressed for business. I went over and he introduced himself as Jordan Robards. I was stoked. I did a double take. He didn't look exactly like the publicity shots on the back of his book, but then again, who does, right?
That makes sense. Go on.
So this guy tells me he is only allowed to sign copies of the book at official signings, but he has one in his bag which he signed earlier. It retails for $25 unsigned, but he would let me have it for $100. I thought that was a bit steep, but it was a once-in-a-lifetime chance. I paid him the money, and he added my name above the signature in the book. He seemed like a really good guy. I pulled out my phone and he was happy to pose for some pics with me. Anyway, I rushed home and put the pics up on Facebook. My friends were rather unimpressed though.
Aren't they fans of Mr. Roberts?
Oh, they're all super fans. That's why they were unimpressed. Turns out they were all at the book signing, and this guy who I gave $100 to was definitely not Jordan Robards. I got completely ripped off.
Do you know who the person was who actually signed your book?
Yeah, he's some guy who works in a menswear store in town. I went to him and asked for my $100 back, but he just laughed and said that I'd agreed to the price. But I only agreed because he said he was Jordan Robards.
That's quite a tale. Let me think about what we might do.
Dear, dear. Alrighty. So that's the answer. So poor old Lord Mitchell of the 7 Golden Orbs got dudded. So how do we frame our issue statement here? What's the legal issue at stake? What does normally the issue statement will cover off 2 things: what your client wants or wants to avoid, and what the legal issue is. Okay. Normally just short, sharp, and shiny. Is Mitchell's contract tainted by unilateral mistake as to identity and therefore void? Okay. The rules are just the rules that we've discussed, so we don't have to go over those again. For contracts face-to-face, there's a presumption that you intend to make the contract in front of you. The elements: A intends to contract with C, not B. A took reasonable steps to ensure B was C. B knew or should have been aware of A's intentions. So where would you start with this one? What are you going to be telling the marker first? Have you gone over, did any of you folks have a little look at my IRAC, AJ's IRAC top tips document? In the chat box, 1 if yes, number 2 if no. 1 if yes, 2 if no, 3 if you're thinking, AJ, can you please just stop talking? I want to go and have dinner now. Oh, Dion's saying earlier in term. I would really recommend that you folks have a little look at that, because that will really help you get your heads around what you should be looking at writing in an IRAC answer. I know that your midterm paper required you to do a little mini IRAC, didn't it? Is that a yes or no? Yes. So, yeah, that's what I thought. So you need to be coming to grips with IRAC, particularly before you take home paper at the end of term. So I would recommend having a little look at my AJ's IRAC tips, because, you know, it's fairly easy formula once you understand it, particularly the formula for the application section, because the application section is where you'll pick up 90% of your marks. And the usual formula, if you read enough cases, you'll see that, you know, most legal reasoning proceeds from telling your audience what the general statement of principle is, looking at relevant cases in the area, and then applying the general statement and the case law to your facts to then give a nicely legally supported conclusion at the end. Okay, usually runs general statement. This is the area of the law. This is the principle at stake. Here's a good case to flesh that out. What does that case tell me about how a court would conclude in these particular facts that we're given? That's usually the 3 steps that you'll go through. So it's reasoning by analogy. You're saying, this is what the law is. Well, applying that to our facts, this is how things would wash up. That's the whole point of the doctrine of precedent, isn't it? You look at what's out there and you say, how close is it to what we've got going on here? If it's on all fours, then you can reasonably confidently say a court is going to decide the same way. Yes, that's the whole process of legal reasoning. I'm sure Peter's been through this with you before. So where would we start here? We'd be telling the marker that there is a presumption here, because this is a case of unilateral mistake as to identity where the parties are inter presentes. Okay, you're giving a little bit of support there for your contention. So the question is whether he's going to have done enough to rebut the presumption. Then you're going to be saying, okay, well, what case law is out there? What case, I think it was either Jasmine or Renee who said that they had a little half look at the materials. Which is the case that's probably closest to our facts here? Anyone got any idea? It's actually Lewis and Avery. So in this case, we had a rogue impersonating Richard Green, and a poor little person was selling their car. The rogue said they were Richard Green, showed an official looking pass from movie studios, which purportedly proved that he was this famous actor, Richard Green. The plaintiff accepted the check, allowed the rogue to take the car. However, the check was dishonoured and the plaintiff's car was on-sold by the rogue to a third party. So something similar to that scenario I described right at the beginning. The court held that checking the rogue's own ID was insufficient to rebut the presumption that the plaintiff intended to deal with the person physically present. The actual mistake was unsuccessful. Okay, so then you flag for the marker that you're going to then be applying the case law to your facts, because this is an application section. How do you flag it for the marker? Say something obvious like applying. Oh, in this case, it appears that Mitchell, like the plaintiff in Lewis and Avery, didn't take enough steps to rebut the presumption.
Sure. Yeah.
Mitchell says that when Jordan Roberts waved him over, he didn't look exactly like the publicity shots on the back of his book. So he obviously had some kind of misgiving about whether this person was Jordan Roberts, but he didn't ask for any ID. And he still didn't even know what the case was when he took photos. It was only when his friends said on Facebook that this wasn't the guy that Mitchell realised. So he'd done even less than the person in Lewis and Avery in terms of checking. Okay, so you could reasonably confidently say, here, to be even less in the way of steps. The rogue didn't offer any ID except calling himself Jordan Roberts. Mitchell just believed the mere assertion without anything more. You could probably say at that point, well, I think that he is not going to be able to rebut the presumption. Here, I've included another case just for a bit of swagger, just to kind of, flex on the marker and say, look, not only do I know what the closest case is, I can actually show you that I know that there's another case out there that is something similar, but, they were successful in that case, but again, it's not going to apply to our facts. You'll read about Ingram and Little in Gore. But in that case, it involved another car sale. And this group of little old ladies who were sisters were selling their car. One of them checked in the phone book to ascertain the rogue's identity. But just checking in the phone book actually in a prior case had been held insufficient. The only thing that saved the little old ladies in that case was the fact that one of them got annoyed and said, no, I don't trust, I don't feel comfortable. And she called the deal off. And it was only that while she was having this altercation with the person that was trying to buy the car, it's only when someone, one of the other sisters ran off, checked the phone book, those two facts together, the fact that she had actually said, no, I'm not sure, and the other sister had gone to check and said to the sister, no, it's all right, I've checked, that together then made the court say, that's okay, I think you've done enough, the presumption's rebutted, and you can, that the contract was, they could back out of the contract. However, that case has been doubted, and I think once you read the resources for this week, you'll see why. So again, Mitchell didn't check anything, so that case doesn't really assist him any further. And at that point, you could probably conclude that Mitchell can't get his money back. Now, there is more to it in terms of the answer guide, and I've given you, what I would expect to see in an HD answer, because you probably have to just run through the elements as well. What I've given you there is probably, a reasonable kind of credit level answer. And what I would expect for an HD would be some discussion about the elements. And as we move forward into our vitiating factors for the following weeks, there are more elements that you have to hop over each hurdle before you know whether or not you've established the cause of action or not in that particular vitiating factor. So you need to get used to setting up an element, and matching it up against the facts and concluding whether that element was satisfied or not, moving on to the next element. Matching it up to the facts, concluding, moving on to your last element. That's what you need to do. In torts, you particularly need to work with elements a lot, and in crim. So it's a good little discussion at the back of my answer guide there, just how you would, what it would look like, just stepping through the elements there to show the marker. Okay, well, you know how this thing probably would have turned out, but in terms of proving this cause of action, this is what we would have had to do. Okay. Do we have any queries or questions on that? Or are you all a bit dumbfounded for tonight? It's a lot, isn't it?
I just have a quick question, just a general question.
Yeah.
With presumptions, are they just kind of out of the picture with intention to create legal relations? Is that where the objective test lies and the presumption is still with every other part?
So what are you saying about, where are you bringing in intention to create legal relations here?
Sorry, I just, in my brain, I thought that the presumption sort of test was gone because of homogeneous, but I think I've thought maybe too much into it.
So homogeneous, that, okay, I understand where you're going now. So a presumption is just a legal term that can apply in many, many different situations. And it's really just legal shorthand, if you will. A presumption just means that instead of having to prove one thing or another thing, the court just says, we're going to make it real easy for you. We're going to presume that this is the case. And then everyone just goes, oh, okay. And you don't have to lead evidence about that. It's just presumed. And the only way that you can get around that presumption is by rebutting it. Now, when you come to crim, you'll find that there are some irrebuttable presumptions. You can't get around them. But with contract, they're all rebuttable. So homogeneous was one area of the law where there was some presumptions. And that was obviously if you had, a social context, it was presumed that there was no intention to create legal relations. If it was a commercial context, it was presumed that there was intention to create legal relations. And then, that's the starting point. And then if you wanted to, knock that presumption down, you had to lead evidence to rebut the presumption, yes? But homogeneous said, no, that's all swept away now because you can't presume anything in terms of intention. What you're going to do is an objective test, and you just have to run past those few factors that they said that you need to be looking at and objectively look at the whole facts of the scenario and say, does it look like they had intention to create legal relations there? Now, that's just one little snippet of presumptions in the law. Presumptions are scattered right throughout the law. And so this invitiating factors in the area of a unilateral mistake as to identity, there is this little presumption that lives here. And this little presumption says that if you've got two parties that are face-to-face, inter presentes, and one wants to back out of the contract that was concluded, then the problem for that party is going to be that the law presumes that they intended to contract with the person that was standing right there in front of them. Okay, just another example of presumptions operating within the law. Okay. Does that make sense?
Yes, thank you.
Cool. Any other queries? That was a very good question, by the way. Yay. Any other queries? No? Cool. Okay. AJ, stop talking now. All right. Well, thank you folks for attending. And that's it for me for this evening. Like I said, if you've got any queries or questions, just pop them up on Teams. I'm always haunting the Teams pages, so please just chat to me in Teams. Other than that, have a lovely week, and I look forward to seeing you next week. Thanks, folks. Bye.
Thanks, AJ.
No worries. Bye-bye.
Thank you.
Okay, bye. Bye now.